Hi everyone, my name is Emily. I am going to share my PowerPoint. Okay. So, hi everyone, my name is Emily. I am a staff attorney with Contra Costa Senior Legal Services, and I'm here today to talk about elder abuse and some of the signs and legal remedies for this. First, I am an attorney with Contra Costa Senior Legal Services. I'm sorry, was I muted? Sorry, I just got muted. Can everyone hear me?
Yes, I can hear
Oh,
you.
okay,
Yes.
okay, thanks. So we provide free legal services for Contra Costa County residents who are age 60 and older. And we provide legal services in the areas of elder abuse, preservation of housing, consumer issues, advanced healthcare directives of attorney, and public benefits, such as issues with Social Security. So today we're going to learn about elder abuse and restraining orders. We'll talk about how we can screen clients for signs of elder abuse, what can a restraining order do and not do, and what is the process of applying for an elder abuse restraining order. We'll also talk about evaluating when a restraining order may or may not be appropriate for a client. And we will talk about some of the resources available to victims of elder abuse in Contra Costa County. So with the world of restraining orders, it's a little bit of an alphabet soup. There are a lot of acronyms. The primary one that we will be talking about today is the EARO. This is an elder abuse restraining order. And that'll be one of the focuses of today's presentation. So first, let's talk about what is elder and dependent adult abuse. So first, what does an elder mean? California law says that an elder is someone who is 65 years or older. So this is important to keep in mind for those of us who work with adults who are younger than 65. So for those of us who work with adults who are younger, we should keep in mind that they actually don't count as an elder under California's elder abuse statute. If someone is younger than 65, then you should screen them to see if they are a dependent adult, because dependent adults also qualify for protection under California's elder abuse and dependent adult abuse statute. So a dependent adult is someone who is age 18 to 64 years old who has physical or mental limitations that restrict that person's ability to carry out normal activities or protect his or her rights. And it's important to keep in mind that this is a functional test. It's not linked to any specific diagnosis, so it's more about whether the person needs help with day-to-day activities such as bathing or feeding themselves. And dependent adults may have multiple limitations that all kind of combine to make it so that they essentially need help carrying out the normal activities of daily life. So let's think about what makes our elders and dependent adults vulnerable. Feel free to share if you have any ideas.
Emily, this is Robin. Maybe just the fact that they're old and physically frail makes people 65 and older more vulnerable to abuse.
Absolutely.
This is Blanca. I'm thinking cognitive decline.
That's a huge vulnerability for a lot of our seniors.
This is Jennifer. I would say isolation because they don't have connections. They may not have connections with family members or people in the community, so they're kind of isolated. So they're not up to speed on the different things, and they can be easily abused because they're only themselves. They don't have any advocates.
Absolutely.
This is Lorena with IHS Public Authority. I'm thinking many consumers who are dependent on others to care for them or to get them those essential daily needs met.
Mm-hmm. That too. Those are all great answers. So a lot of
yes, I
go
also
ahead.
would like to contribute. I think that they're not very tech savvy in comparison to people of today.
Yes, I agree. And that can also contribute to isolation and make it harder for them to access resources, such as online resources. So a lot of all your answers were great. Risk factors include isolation. If a senior is isolated at home, perhaps with their abuser, it can make it harder for them to seek help. It can make it harder for others to come in and recognize the abuse and help the senior seek help. If a senior is isolated with their abuser, they may start to identify with the abuser and in some cases may not even realize that what's going on is abuse. Many of our seniors have disabilities, and this also can be a contributing factor and make someone more vulnerable. If someone has a disability, they may rely on a caregiver for help, and that might make the person or the elder reluctant to seek help for the abuse because they worry that if they seek help, they will lose their caregiver. Many seniors are lonely, and this is also a risk factor for elder abuse. This includes scams, which are a form of elder abuse. Seniors who are lonely might be more likely to pick up the phone and talk to the scammer or fall for romance scams. Many seniors are scared about what might happen if they speak up about elder abuse, and this can help perpetuate the abuse. Many of our seniors, they have a desire for independence, and they might fear what will happen if they speak up and seek help for the abuse. They might fear that they will no longer be able to live at home, that they'll be put in a nursing home, or they'll have their independence taken away. And a lot of our seniors are embarrassed about what might be happening to them if they're being abused. This is often the case with seniors who are scammed. A lot of times they're embarrassed about what happened. And so many seniors don't report scams and they don't seek help because they're ashamed and they worry that they will lose their independence if they speak up and seek help. I want to talk briefly about capacity. As those of you who work with seniors probably know, in some cases, our clients may not have the ability to make decisions for themselves. Sometimes our seniors have some cognitive impairments, but they still might be able to ask for help. It can be tricky to evaluate capacity sometimes. Capacity also is not a fixed thing. It can vary. So a senior who's on medication, for instance, may have capacity in some part of the day, but later on, they may have more cognitive challenges that come up. If you're talking with a senior, some of the signs that they may be having an issue with capacity include if you have a client who's calling you multiple times, either in a day, a week, or a month, and they're not remembering your previous conversations. If a client has trouble telling you basic details of their lives, such as their address or their date of birth, or if a client doesn't know why they're there to see you. These are signs that the client may be having issues with capacity. So who experiences elder abuse? Seniors across all socioeconomic groups, cultures, races, backgrounds experience elder abuse. Women are more likely to be affected by elder abuse. Elders who lack capacity, such as those with dementia, are more vulnerable and more likely to experience abuse. And approximately 1 in 10 Americans age 60 and up have experienced some form of elder abuse. So elder abuse is very common.
Sure, 1 minute faster.
So there are many different types of abuse in California. One type of elder abuse is physical abuse, and this can include something like hitting or pushing an elder. It also includes using an inappropriate restraint on an elder, such as having an elder be tied down in a bed. It can include depriving an elder of food or water, and then it also includes medication misuse. And medication misuse is when someone is over medicated or administered drugs for a purpose that wasn't authorized by a physician. And this is something that is or can happen in long-term care facilities, for example. Other types of elder abuse include sexual abuse, which is really just any form of non-consensual sexual activity. Elder abuse includes mental or emotional abuse. This can include harassment and intimidation that causes emotional distress or fear, such as name calling, threats to put in a home. It can include yelling at an elder. Elder abuse also includes isolation, so isolating an elder from others, not letting an elder come to the door and greet visitors, not letting an elder talk on the phone. That all constitutes elder abuse. Elder abuse includes deprivation by a care custodian or caregiver of services or things that the elder needs to avoid harm or suffering. So if an elder has a caregiver or someone who's supposed to take care of them, and the caregiver isn't making sure that the elder gets their medication, or they're not bathing the elder or feeding the elder, that all can include or all can constitute elder abuse. Elder abuse also includes neglect or abandonment. And then it also just includes any other treatment that results in physical harm, pain, or mental suffering. So there are many different forms of elder abuse here in California. Another form of elder abuse is financial abuse. And financial abuse is really just taking a senior's property or assets for wrongful use, or helping with this. And financial abuse is the most common form of elder abuse that is reported to Contra Costa County's Adult Protective Services after self-neglect. So financial abuse is very common. Some examples of financial abuse include we have a scammer who convinces a senior to wire money to a foreign country for an investment. If we have a daughter who agrees to help her mother pay the mom's bills, but then the daughter writes checks to herself from the mom's account, that is elder abuse. If a senior has a new friend who gets the senior's social security number and opens up credit cards in the senior's name, that is absolutely financial abuse. Also, if we have a financial advisor who asks a senior to invest in the advisor's side business, and the side business turns out to be fake, that also constitutes financial abuse. It's important to remember that scams are financial abuse. Unfortunately, a restraining order is not going to help someone who was scammed typically, and it can be very difficult, if not impossible, to get back money from a scammer. So with scams, prevention is the best weapon. So it's important to know the signs of a scam. Some of these include any pressure to pay today or the offer will end, threats that you or maybe a family member will be arrested or charged with a crime. It's probably a scam. Asking for payment via wire transfer, gift cards, maybe large amounts of cash or cryptocurrency. That's a sign of a scam. Also, if you get an email from someone and the name or the email address has small changes, weird punctuation, misspellings, that can be a sign that it's from a scammer. And also seniors should be told to trust their gut. If something feels off, then it probably is. So elder abuse is very common in Contra Costa County. Last year, there were 5,851 elder abuse allegations made to our adult protective services, and self-neglect was the most common, but after that, we had financial exploitation was the most common form of elder abuse that was reported. So financial abuse is very, very common. So who are the abusers? An abuser can be almost anyone. Often an abuser is a family member. In my work, the most common abusers are family members of the elder. Often these are the elder's adult children, maybe grandchildren, siblings, spouses. They are often the ones who are committing elder abuse. Caregivers also commit elder abuse, whether by neglecting the elder or physically abusing the elder or mentally abusing the elder. Friends can commit elder abuse, so people who befriend the senior, perhaps with the ultimate goal of stealing the senior's money. Financial advisors and lawyers can commit elder abuse. And then also just strangers and scam artists commit elder abuse. And these are often the people who are scamming our clients. So some of the signs of elder abuse include if a senior stops participating in activities they once enjoyed. So maybe the senior is always going to the senior center and then all of a sudden they stop coming. That's a sign that maybe something is wrong with the senior. If someone looks messy or unkempt, like they're not being taken care of, if someone is having trouble sleeping or losing weight unexpectedly, if someone becomes withdrawn or is acting violent or agitated, or if someone's showing signs of trauma, such as rocking back and forth, or if someone has unexplained injuries, such as a bruise, burn, cut, scar. These are all signs that someone may be experiencing elder abuse. Also, if someone has broken eyeglasses or is showing some signs of punishment or restraint, if someone has bed sores or some other preventable condition, this is more common perhaps with people who are bedbound, maybe people who are in long-term care facilities. If someone doesn't have the medical aids that they need, maybe glasses or a hearing aid, or they are supposed to have medication that they don't have, that's a sign that elder abuse may be happening. If someone lives in hazardous, unclean, or unsafe conditions, maybe that person is being neglected, or maybe they've been abandoned by the people who were supposed to take care of them. If someone has unpaid rent or receives a notice that they're being evicted or a notice that their mortgage is late, these can all be signs of elder abuse. Either because the person who's supposed to help them pay their rent, for example, is neglecting them and not helping them, or this can also be a result of financial abuse. If a senior loses enough money, they may not have enough left over to pay their rent or mortgage. And then if someone is showing signs of insufficient care or unpaid bills, despite having adequate financial resources, this can also be a sign of elder abuse. Maybe the senior has someone who's supposed to be helping them pay their bills, and this person is neglecting them. That's a sign that something is wrong. So some of us are mandated reporters, so we're required to report elder abuse. This includes a lot of people who may work with seniors, but not all of us are going to be required to report elder abuse. So let's talk about a scenario. Mary is a 75-year-old woman who lives with her daughter, Catherine. Mary is in a wheelchair and she cannot dress or bathe without help. Mary relies on Catherine to take care of her. And when you speak to Mary alone, Mary tells you that Catherine yells at her when she's frustrated, but Mary relies on Catherine for help. And then Catherine tells you that Mary doesn't know what's going on, but Mary is able to communicate with you pretty easily when you talk to Mary. So do we see any signs of elder abuse here? Or vulnerabilities?
Well, I'll kind of break it a little bit. So, she's basically telling you that Catherine is yelling at her when she's alone and they're alone together. So that's one sign.
Absolutely. We also see that Mary has certain vulnerabilities that might make her more vulnerable to elder abuse.
We have some in the chat too. Mobility capacity, physical incapacity, and tells you Mary doesn't know what's going on.
Yeah, so the fact that Mary relies on Catherine absolutely makes her more vulnerable. Catherine yelling at Mary absolutely could constitute elder abuse. We see that Mary is telling you, Mary's able to communicate with us pretty easily, but Catherine is saying that Mary doesn't know what's going on. The fact that Mary is able to communicate with us pretty easily is maybe a sign that Mary doesn't have capacity issues. And this is something that often can come up with our seniors. And this is why it can be important for us to meet with Mary privately without Catherine in the room so that we can talk to Mary and get a sense of what's really going on with Mary rather than just letting Catherine tell us what's going on with her. So now I want to talk a little bit about elder abuse restraining orders. And this is a type of restraining order that is for elders who are age 65 and up, or for dependent adults who are experiencing some form of abuse. So first, let's talk about what is required for an elder abuse restraining order. So first, the petitioner, this is the elder or dependent adult who needs protection, they have to tell the court, often through some kind of written statement, that the person they want restrained, that would be the abuser, has committed an act or acts of elder abuse. So the most basic thing is that the person who needs protection, who's being abused, has to tell the court that the abuser has committed some act of elder abuse against them. An elder abuse restraining order or I'll say the initial temporary restraining order that you can get can be issued with or without notice to the person being restrained. So you can go to court and get a temporary restraining order without notifying the abuser that you are doing this. And when you apply for an elder abuse restraining order, the petitioner, the person who needs protection, is under penalty of perjury. And so it's best to get all the facts of the abuse and what's going on into the application so that the judge has them in front of him or her. So who can apply for an elder abuse restraining order? First, the elder or the dependent adult who needs protection can apply for the restraining order to protect themselves. Others can also apply for an elder abuse restraining order. A guardian ad litem or conservator can apply for an elder abuse restraining order. If an elder set up a power of attorney and say they designated, a family member or someone else to be their attorney in fact under the power of attorney, then that attorney in fact can apply for an elder abuse restraining order to protect the elder. Adult Protective Services can, under some circumstances, apply for an elder abuse restraining order on behalf of a senior or dependent adult. APS can do this when the elder gives written authorization for this, or when the elder's ability to comprehend the risk of harm is impaired. And then the law allows for others with legal authorization to apply for an elder abuse restraining order. So elder abuse restraining orders can be really helpful for some seniors. Some of the advantages of an elder abuse restraining order include that they can be used to protect someone who lacks capacity. So if someone is conserved, for instance, the conservator can apply for this restraining order to protect the senior who lacks capacity. An elder abuse restraining order can be renewed and made permanent, so it can be in place for the rest of the elder's lifetime. Protection is also available in cases where the abuse is exclusively financial abuse. So you don't need to show other forms of abuse to get an elder abuse restraining order. Unlike with a domestic violence restraining order, there is no relationship requirement between the abuser and the person who's being protected. So it doesn't matter what is the relationship between the elder or dependent adult and the abuser, as long as the elder is 65 or older, or the person qualifies as a dependent adult, they can apply for an elder abuse restraining order. Elder abuse restraining orders have a lower burden of proof than the civil harassment restraining order. And what this really gets at is the way that an elder has to prove their case in court, and how convincing they have to be in terms of proving that the elder abuse happened in court. An elder abuse restraining order is designed to be flexible. So it's designed so that an elder can ask for whatever orders that they might need to be put in place to keep the elder safe. Elder abuse restraining orders, however, they're not perfect. They can't do everything. Some of the disadvantages of an elder abuse restraining order can include that they don't have as many available orders as a domestic violence restraining order. For instance, an elder abuse restraining order doesn't allow someone to get spousal support from a spouse. An elder abuse restraining order also is not a good tool for recovering money. And then elder abuse restraining orders, as with any restraining order, can be challenging to enforce depending on the circumstances. So if you live with someone or you're someone's neighbor, an elder abuse restraining order can be tough to enforce because you're still in such close proximity to that abusive person. So quickly, let's just compare domestic violence restraining orders and elder abuse restraining orders. They can do similar things, such as give an order that someone not be abusive. They have different forms that you fill out to get them. The procedure is similar, and they have the same burden of proof in court. Though domestic violence restraining orders are something you get in family court, elder abuse restraining orders are something you get in civil court. And many of us, because many elders are being abused by family members, many of our clients can qualify for either the elder abuse restraining order or the domestic violence restraining order. So let's talk a little bit about what can a restraining order do for seniors. And these are the orders that an elder can obtain in an elder abuse restraining order. So an elder can ask that their restraining order include a stay away order. And a stay away order is an order that the restrained party or the abuser is ordered not to come within a certain distance of the elder or dependent adult, other protected parties, such as if a caregiver is added to the restraining order, then the abuser might have to stay away from the caregiver. The abuser can be ordered to stay away from the elder's home, their job or workplace, the elder's vehicle, if they have one, and any other locations that the elder might go. So the stay away order, I always liken it to like a bubble, and the elder is at the center of the bubble. So wherever the elder goes, the abuser has to stay a certain distance away from them, wherever they are. So if they're at the doctor or the senior center, the abuser will have to stay away from them, wherever it is that they are. Another form of available order is called a personal conduct order. And this includes an order of no abuse. So with an order of no abuse, the restrained party is ordered not to physically abuse, financially abuse, intimidate, molest, assault, attack, stalk, threaten, harass, destroy the property of, or disturb the peace of the protected person. So this would include all the forms of elder abuse that we talked about earlier. With a personal conduct order, you can also get an order that the abuser have no contact with the elder or dependent adult. And this includes both direct contact and indirect contact. So the abuser isn't going to be allowed to call the elder on the phone or send them text messages or send them letters in the mail. And then the abuser is also going to be ordered not to go to someone else and ask that third party to pass on messages to the senior. And then an elder abuse restraining order also can include a catch-all of the judge can make any other orders that are needed to protect the senior from harmful or abusive behavior. This can include orders protecting a senior's pets, and then it can include other orders. For instance, if a senior was coerced into buying a car for the abuser can be ordered to return the car to the senior. And then the other main form of order that you can get in an elder abuse restraining order is something called a move-out order. And to get a move-out order in a temporary restraining order, you have to show that the elder has the right to possession of the premises, and we'll talk about what that means on the next slide. You have to show that the party to be excluded, so the abuser, has either assaulted or threatened to assault the petitioner. So that the petitioner would be the elder or dependent adult, or the person such as the conservator who's applying for this restraining order for an elder. And you have to show that physical or emotional harm would result if the move-out order isn't temporarily granted. So to get a move-out order and a temporary restraining order, you essentially have to show that there has been physical abuse or a threat of physical abuse. So it's a little bit narrower when you can get the temporary move-out order. With move-out orders, when we talk about the elder's right to possession of the property that they have to show, this means that the elder must have an equal or greater right to live in the home. And this also means that the title or lease to the residence is not in the name of the respondent only. So it's not in the name of the abuser only, or in the name of the abuser and a third party. So for example, if an elder rents a room in a home and the landlord owns the home and the elder wants a restraining order against their landlord, the elder is not going to be able to get a move-out order against their landlord because the landlord owns the home and the elder does not own the home. The elder is just a tenant. To get a restraining order, a permanent restraining order, so to get a restraining order at a hearing, you don't need to show that physical abuse or a threat of physical abuse has occurred. So when a senior goes to a hearing and the judge is going to decide whether to grant the restraining order or not, and whether to grant the move-out order, the judge can grant the move-out order even if no physical abuse has happened. And this is important because someone who is suffering financial abuse only can't get a move-out order in the temporary restraining order, but they can get the move-out order in any restraining order that's granted at the hearing. I will say, however, judges can be reluctant to order someone to move out if there hasn't been some kind of physical abuse or a threat of physical abuse. So it can be harder to get a move out order if no physical abuse or threats of physical abuse have happened. A little more about move out orders, because these are something that a lot of clients want but aren't necessarily going to get, is that restraining orders should not be thought of as an alternative tool to either obtain an eviction or even to fight an eviction. Judges are wary of people trying to use restraining orders as an alternate means of getting someone evicted. So the client may be better off just seeking an eviction instead of a restraining order, depending on the facts of the case and what kind of abuse is happening. I'll note that the mere fact of another person's refusing to leave a client's home or refusing to pay rent, those do not by themselves constitute abuse. So the mere fact that someone isn't paying rent, you're not going to get a restraining order for that. So let's check our knowledge now. A woman comes in and says that her nephew is abusing her and she wants a restraining order. She's over 65. Her nephew lives in the house that she has owned for 20 years. Can she exclude him? So can she get a move-out order against him in a restraining order?
A lot of people are saying yes.
So yes, you are all correct. She owns the home. Her nephew lives there. She absolutely can get a restraining order against her nephew. That includes an order that he move out. Now the woman tells you that 5 years ago, she put her nephew on the title to her home with her, but now she wants to take him off the title. Can she still exclude him?
some no's and some yeses. It looks
Wow.
like a lot of no's.
So
Oh.
I'm gonna say yes, she can still exclude him, because they're both on the title, so they're both equally entitled to live in the home. But if she does exclude him, then he can force her to sell the house because he's also on the title. Bonus question, can she take him off the title?
One person saying yes, and some people saying no.
So I'm going to say probably not without some litigation. So they're going to have to go to court, unless the nephew agrees to take himself off the title. So let's just recap a little about elder abuse restraining orders. So who is eligible for an elder abuse restraining order? It is people who are 65 and older and dependent adults. So if you have a client who is only 60, if they're not a dependent adult, they are not eligible to apply for an elder abuse restraining order, and they should be directed to apply to another type of restraining order. And then what is the purpose of an elder abuse restraining order? So the purpose of these is to protect one individual from another and prevent a recurrence of abuse. So an elder abuse restraining order is really about keeping someone safe. An elder abuse restraining order is not about punishing the abuser or seeking revenge on the abuser. So sometimes our clients come to us and their main goal is to punish the abuser, to have the abuser charged with a crime and potentially go to jail. An elder abuse restraining order is not going to help achieve that goal, because it's just about keeping the elder or dependent adult safe. And nobody is charged with a crime just because an elder abuse restraining order is issued against them. Sorry. So, quick recap, what can an elder abuse restraining order do? It can include a stay away order from an elder or dependent adult, the elder's home, the elder's car, or other places the elder frequents, like a workplace. It can include a conduct order of no abuse and no contact. It can include an order that the abuser move out of the elder's home, and it can include an order protecting animals belonging to the abuser. And that can include an order that the abuser stay away from the animal and not be abusive to the animal. And it can also include an order giving the elder possession of the animal. An elder abuse restraining order can't order an abuser to seek mental health or substance use treatment. An elder abuse restraining order cannot be used to order the abuser to pay money to the elder. It can't be used to recover the elder's assets, and it's not something that's going to send the abuser to jail or result in a criminal case against the abuser. So it's not going to be about punishing the abuser. So if you have a client who comes to you and says their goal is recovering all the money that their grandson took, maybe an elder abuse restraining order isn't going to be the best option for that senior. So let's do a quick scenario. We have Paul. He is 85 and lives in his home alone. He is a generous person and a beloved member of his family and community. Dave, his ex-wife's son, asks Paul if Dave can move in when Dave needs a place, and Paul says yes. A few months later, Paul's friend asks if a relative, Sheila, can move into Paul's in-law unit because Sheila needs a place to stay. Dave and Sheila start dating. Sheila becomes paranoid and starts yelling at Paul. When Paul asks Sheila to move out, Sheila stands over Paul in his chair, grabs Paul's remote, yells at Paul that she'll kill herself if Paul kicks Sheila out. Later, Dave corners Paul in the bathroom and tells Paul that if Sheila hurts herself, it would be Paul's fault. Paul feels intimidated by Dave and Sheila, and he wants them to move out. So can Paul file for a restraining order, and what might be the abuse that's going on here? What is the abuse here?
One person saying yes, verbal abuse. There's a few yeses, mental and financial. And then one person saying yes, start an eviction process.
So those are great comments. Absolutely mental, verbal abuse is going on here. Yelling at Paul, threatening to kill herself if Paul kicks her out. That absolutely is abusive and manipulative. And I'm going to say that Paul can apply for a restraining order, though I'm going to say that just based on this, I don't know that Paul is going to be able to get an order that they move out. It's going to be harder for Paul to get that order that they have to move out. So the comment that Paul should seek an eviction, I think that's a great comment. I would probably advise Paul to seek an eviction and also go the restraining order route and hope that something sticks. Can anyone think of any other services we might offer Paul?
One person is saying a stay away order, counseling, APS being involved.
Yeah, I think those are all great options. As all of you who work with seniors know, seniors have many of our survivors have a whole scope of needs, and a restraining order isn't going to meet all of those needs. So something like counseling, adult protective services, those are all great options for Paul. So now I want to talk a little bit about the elder abuse restraining order procedure. So step one is you fill out the set of elder abuse restraining order forms, and at least in Contra Costa County, those have to be filed at the courthouse in Martinez any weekday morning from 9 to 10:30. You take your forms to the court, and then a judge looks at them, and then someone from the court calls the elder and tells the elder to come and pick up the forms when they are ready. The next step is you have to have the respondent, and the respondent is the abuser. You have to have that respondent served with one copy of all the documents that the elder filed at the court, plus a blank response form. And this has to happen 5 days before the hearing. So when I say that we have to serve the respondent, what I mean is that someone who's 18 or older besides the senior has to give the respondent a copy of these forms in person. They can't be mailed. They can't be left at the respondent's home or workplace. They have to actually be given to the abuser in person. Then once that happens, the elder has to appear at the court hearing. And this is where the elder goes to court, sits before the judge talks to the elder about what the abuse is, asks the elder questions. There can be other witnesses or evidence that the elder presents. The elder will talk to the abuser if the abuser is there, and then the judge decides whether or not they're going to grant the restraining order, and they decide what the restraining order will do. For instance, it's up to the judge at the hearing whether the restraining order will include a move-out order or not. And if the judge does agree to issue the restraining order, then it is the elder's responsibility to make sure that the final order, that's the order after hearing, OAH, it's the elder's responsibility to make sure that this final restraining order is served to the abuser if the abuser was not at the hearing. And this is a necessary step because the police won't enforce the order if it hasn't been served. And this can often happen in the mail by mailing the abuser a copy of that final restraining order, or it's possible that the abuser might have to be served in person. So the elder might have to have someone give a copy of that final restraining order to the abuser in person. It depends on the case, though. So there's a set of forms that gets filled out to apply for the elder abuse restraining order. These are all available online on the Contra Costa County Court's website. And you can get the full packet online, and it has all the forms that anyone will need. Here in Contra Costa County, also, people can go to the family court in Martinez, and the family court in Martinez will give out free elder abuse restraining order packets. And they also have free packets of other types of restraining orders as well. So that's a great option for people who just want to be able to go to court, get the forms, fill them out, and submit them right then and there. I mentioned earlier about temporary restraining orders. So when you apply for a restraining order, you can ask that the judge give you a temporary restraining order. And a temporary restraining order is just that. It's a restraining order that is temporary, and it is a restraining order that is in place until the senior goes to court and has their hearing and sees the judge. Usually there's about a 3-week gap from when someone applies for a restraining order to when they actually go to court and have the hearing. And so the point of a temporary restraining order is to keep the elder safe over those 3 weeks. And so you can request the temporary restraining order when you submit your restraining order application to the court. And the judge will either grant it or deny it. As I mentioned, you have to serve your restraining order, and service has to be personal. So you have to give the responding party, that's the abuser, copies of all of the documents in the case. That includes a copy of any temporary restraining order that has been issued. And whoever serves the documents has to fill out a proof of service. And a proof of service is a form that the server fills out, and they say that they serve the documents, here's what documents they gave the abuser, here's when and where this happened. And then this proof of service form has to be submitted to the court. And this is how the judge knows that the restraining order documents were served, and the judge knows that they can go ahead and grant this restraining order. And the sheriff will serve restraining order documents, usually for free. Elder abuse restraining order documents can be served for free. I'll mention that the responding party, so that's the abuser, they can file a response to the elder's restraining order application. So the abuser has rights, and they have the right to respond and tell their side of the story. So for some of our clients, serving people can be the most challenging aspect of applying for a restraining order. This is often the case when you want a restraining order against someone who's homeless and doesn't have a fixed address. So sometimes serving people can be the biggest obstacle to a successful restraining order case. So you want to, if you're talking to a senior, get as much specific information as possible on where to find the abuser. Maybe search social media and see if someone is spending time at certain locations where you can go and look for that person. You can search court records. You could try asking others who know the abuser, such as former coworkers, who might be able to give you tips on where to find the person. You can try sending them something in the mail, return service requested, to try to get more information about the person's address. But serving someone absolutely is important and necessary. So I mentioned earlier, you had the final step in the restraining order process is having the hearing. And the judge can only proceed with the restraining order hearing if personal service was completed. So the judge can only have the restraining order hearing if the abuser was given a copy of all of the documents from the case. And if the abuser was not personally served, then the judge will continue the hearing and reissue the temporary restraining order upon request. So what that means is you'll go to court and the judge will postpone your hearing for a future day. Will hopefully reissue the temporary restraining order so that it remains in place. And then you'll have more time to get the other person served. At the hearing, the petitioner, so that's the elder or dependent adult, they have to be ready to argue their case. They should bring evidence, witnesses if they have them. They should be prepared to answer questions about the abuse, like what happened, when it happened. And it's common for petitioners in restraining order cases to not have attorneys. So many people who apply for restraining orders don't have an attorney representing them. So if the, like I mentioned, if personal service hasn't been completed, the hearing will get postponed. And if the requesting party, so if the elder or dependent adult is a no-show at the hearing, the temporary restraining order expires and the case is dismissed and no restraining order is going to be granted in the case. So it's absolutely important that the person who wants the restraining order show up at court for any court dates. Our courts in Contra Costa County, they offer free mediation, and a restraining order can last up to 5 years. And the burden of proof in a elder abuse restraining order case is the preponderance of the evidence. So what that really means is the senior has to prove that, to the judge, make the judge believe that it's more likely than not that what the senior is saying is true. It's more likely than not that the abuse has occurred. Elder abuse restraining orders can be renewed. It's important that we tell seniors that they can be renewed, because the renewal can happen within 3 months before the date of expiration. So all restraining orders have an expiration date, and you can renew the restraining order within 3 months before that expiration date. To renew a restraining order, you don't have to show that new abuse has occurred. You don't have to show that the restraining order was violated to get that restraining order renewed. The judge can make the elder abuse restraining order permanent. And it's really important that you apply to renew the restraining order before it expires, because once it expires, you can't renew it. And you have to apply all over again for a new elder abuse restraining order, and you have to show new evidence of abuse or ongoing risk, which might be hard for the senior to show. So let's quickly go through this scenario. Lucia is 68 and lives with her husband who has dementia and her adult son. Lucia is a monolingual Spanish speaker. One day her son brings over a woman named Sharon who says she's homeless with 4 kids. Lucia agrees to let them stay for a couple of weeks until they get back on their feet. However, they end up staying for months and won't leave. Sharon uses drugs regularly and goes on tirades and yells at everyone in the house. Lucia's husband is very disturbed by Sharon's yelling. Lucia finds needles in the bathroom and cleans them up. Sharon leaves for days at a time and doesn't feed the kids enough. Lucia pays for food for the children, even though she doesn't have enough for herself. And Lucia gets behind on rent. Sharon yells at Lucia, but Lucia doesn't always understand exactly what Sharon is saying because Lucia doesn't speak English. Can Lucia apply for a restraining order, and what is the abuse here?
One person says CPS and APS, and then, well, verbal for adults and neglect for children too.
Absolutely.
A lot of verbal, and another one saying to call CPS and APS.
Yeah, absolutely. I think that's spot on. I have seen cases where leaving children with a senior who can't care for the children, you could try to argue that that constitutes abuse as well.
And we have one more that says a temporary stay away order with an eviction and a restraining order.
Yeah, I think trying for a restraining order could be a good idea for Lucia. As far as other services, you guys mentioned some CPS, APS. I think those are great services to offer. Quickly, let's talk about restraining order enforcement. To enforce a restraining order, the person who's protected can call the police. If the restrained person violates the restraining order, the police can come and arrest the restrained person for the violation. However, police responses vary by city. Sometimes the police will be really helpful in responding to the restraining order, sometimes not. How the police respond will vary depending on how the restraining order is violated. And it's possible for a protected person to go back to court for contempt if they document all the violations and make police reports. And the abuser might have to pay a fine, but this is pretty uncommon. And it is the case, unfortunately, that some people do have trouble getting their restraining orders enforced. And it is sadly the case that restraining orders do get violated. So they're not perfect tools in terms of keeping someone safe. So in talking to a client and determining whether a restraining order may or may not be right for the client, some things that we can consider are, what are the client's goals, and can those goals be accomplished with a restraining order? For instance, if the client wants the abuser to stay away from them, then yes, a restraining order might be able to accomplish that goal. If the client wants the abuser to pay them money, then that is something that the restraining order probably can't accomplish. Think about what is the client's age and their relationship to the opposing party. That is important because that will determine what type, if any, of restraining order the client might be eligible for. You should also talk to the client about how recent is the abuse and what is the abuse. That will impact what type of orders a client may be able to get in the restraining order, such as the move-out order. It might impact whether the client's going to be able to get the move-out order. Also, if the abuse is not recent, if the abuse happened 5 years ago, and the client is just now applying for the restraining order, they may have trouble winning that case. The judge is going to wonder, why should I grant this restraining order if the abuse happened, years ago? You should also find out if your client's willing and able to call the police if their restraining order is violated. Some clients don't want to have to deal with the police. And if they're not going to want to call the police, then a restraining order may not do much to help them. If the restraining order does get violated, there'll be no enforcement. So you might want to talk to those clients and come up with alternative strategies for keeping the client safe. You should also explain to the client that getting a restraining order requires going to court and testifying and telling the judge what the abuse is that's going on. Going to court is stressful and scary, and if a client doesn't want to go to court, then a restraining order isn't something they're going to be able to get. You should find out, does the client know where they can find the opposing party? If the client has no idea where the abuser is, then they're not going to be able to serve their restraining order documents, and they're not going to be able to get the restraining order. It's very common that our clients are abused by family members, and those clients may not want a restraining order. They may not want to have a restraining order that says they can't see or talk to their family member. They may be worried about potential consequences for the abusive family member. They may think that what the family member needs is mental health care, and the restraining order isn't gonna fix that issue. They may also want to reconcile with the family member, and a restraining order is not gonna help them reconcile with their family. Getting a restraining order is something that's adversarial and hostile. And for some clients, they don't want to do that. They would rather have peace and reconciliation than something that is hostile going on. So you should be honest with the client about their case. Let them know if you think they're going to have trouble winning their restraining order case. And it's always important to set reasonable expectations. Tell the client that a win in court is not guaranteed. They may succeed in getting the restraining order, but they may not get everything they want in the restraining order. Like they may not get that move out order that they want. And sometimes I've had clients where simply avoiding the other party, the abuser, can help prevent future abuse. So sometimes a restraining order isn't absolutely necessary to keep a client safe, and there are other things the client can do to avoid future abuse. So we're running out of time. Let's quickly do this first scenario. If a client comes to you and says, I need a restraining order against an acquaintance. He came to my house and threatened to kill me. I don't know what to do because he has dementia and now I don't know where he is. Do you see any issues here with what the client is telling you?
One issue would be he doesn't know where the person is, and that would be problematic when it comes to serving. Absolutely.
If you don't know where the person is, you're not going to be able to get a restraining order against them, unfortunately. You have a client who comes to you and says, I know that my neighbor is doing things to my property, but I don't know if I can prove it. Somebody slashed my tires and a window was broken in my house. I know it was him, but he won't admit it. What do we think about this?
One person is saying no.
When you apply for a restraining order, you have to submit evidence of the abuse. And if you haven't seen your neighbor doing those things, it's going to be pretty hard to prove in court to a judge that your neighbor did that and should be restrained. Sorry, I was barking. Okay, so if a client says, my mom is being abused, I want to get a restraining order for her against my sister. She's taking her Social Security checks and spending it on herself. What do we think about this client's situation?
Financial abuse and needs proof of that or a witness.
Yep, and I would also say it's possible that the woman can apply for a restraining order on behalf of the mom, but that's going to depend on maybe whether the mom has a power of attorney in place. Typically, it has to be the elder or dependent adult who applies for their own restraining order. And it's only if the elder has set up a power of attorney that allows the daughter to do it, that the daughter can do it for the mom. Or if the mom is conserved, the daughter might be able to do it on behalf of her mom. So for those seniors who maybe a restraining order isn't the best option for them, there's some other things they can do. They can hire a private attorney to sue the other person for elder abuse. This can be a good option if the client wants to get money back and there are actually assets available to recover. If it's an eviction that is needed, we recommend that the senior hire a private attorney to help with the eviction. Though, of course, a client can file an eviction case themselves at court with help from the court's self-help center. So we're lucky here in Contra Costa County, there are a lot of resources for survivors of elder abuse. We have the Contra Costa Elder Abuse Prevention Project with a lot of great organizations providing services to seniors. Sometimes seniors might come to you wanting mental health treatment for their children instead of a restraining order. That's a common thing that I see often. For these seniors, you might tell them that they should call 211 or look into the Assisted Outpatient Treatment Center. We also have a mental health evaluation team that could be able to help. So there may be options for getting the child the mental health treatment that they need. Some other resources for seniors who are experiencing abuse. Bay Area Legal Aid is a legal aid nonprofit that may be able to help them. The Housing and Economic Rights Advocates also provide legal assistance and may be able to help. If someone wants to hire a private attorney, the County Bar Association has a lawyer referral service that you can use to find a private attorney. So there are a lot of resources for seniors in the county. So quick recap, an elder abuse restraining order is a way to protect seniors from someone who may be abusing them. There are resources available in the county to help with restraining orders and to evaluate whether someone qualifies for a restraining order. Check for the basic requirements. Check that 65 and older or a dependent adult. Check for acts of abuse and make sure that the senior has capacity. So my name is Emily Milstein. I'm a staff attorney with Contra Costa Senior Legal Services. Here's my contact info. They're going to share the PowerPoint with everyone. So feel free to email me or call me if you have questions. And then now we'll do some Q&A as well.
So you can feel free to unmute, but I'll start with one question that I saw earlier in the presentation. So what happens if an abuser is the person who is granted a power of attorney?
So if an abuser, if a senior sets up a power of attorney and they designate someone as their agent, and then that someone becomes abusive, if the senior still has capacity, if the senior doesn't have dementia, they can always revoke the power of attorney and set up a new power of attorney if they want to, designating someone else to be their agent, someone who hopefully won't be abusive. If a senior lacks capacity, however, and their agent is being abusive, the options are more limited. Once a senior lacks capacity, they cannot revoke a power of attorney and they cannot set up a new one. So I would say at that point, what probably needs to happen is the senior might need to be conserved. And as part of that, they can get the power of attorney revoked and stop the agent from having any authority. over the seniors' affairs.
Doesn't look like anyone's unmuting. So another question that was asked, if there was only one physical assault incident and no other prior history of abuse, is that enough for a restraining order?
Yes, there don't have to be multiple instances of abuse. One instance of physical abuse can be enough to get a restraining order. I've had cases where that was the case. I will say, however, you're going to want to think about when the assault occurred. If the assault was recent, then hopefully you would have no trouble getting the restraining order. If the assault occurred 5 years ago, the judge is going to maybe wonder, why are you applying for the restraining order now? The judge might think, if you're really in danger, why didn't you apply for the restraining order 5 years ago when the incident occurred? But yes, there shouldn't need to be more than one instance of abuse.
We have a question from Wanda.
Hey, I was wondering about if you talked about how it can be difficult sometimes for people to be able to serve someone. If they make diligent attempts to serve someone without success, I mean, how can you make a case for the person dodging the serving? And if so, how do you do that? Or is there any other way? Is there ex parte you can do, or is there anything else you can do around that?
That's a great question. So with the domestic violence restraining order, you can make a case that the abuser is dodging, evading service, and make a case for using some alternative means of serving that person. However, elder abuse restraining orders technically they don't allow for alternative service. You can try to argue to the judge that the person is evading service and that you should be able to use some alternative means of service, and maybe the judge will allow it. I've heard of that being allowed in other counties. I have never had a judge agree to allow alternative service in Contra Costa County. But I'm going to say if you think someone's evading service, then by all means, argue to the judge that they should allow alternative service. And this is something that's going to be up to the judge, whether they want to allow it or not.
Thank you.
You're welcome.
And we had another one. Can the elder who is abused get a move out order if she is not on the lease and the abuser is the only one on the lease?
So that's a great question. I'm going to say that the elder may have trouble getting that move out order. The elder can certainly ask for it, but if that's my client, I'm going to advise them that the judge may deny the move out order because the elder is not on the lease and the other person is. But I would say, the elder can try to argue that they should get the move out order. If it's my client, I'm going to ask the elder about how long they've lived in the home, about are the utilities under their name, are they paying the rent or the utilities, and maybe try to build a case for the elder's right to maintain possession of the home. But I think there's a real chance that the judge is potentially going to deny that move out order request.
And I think this was in regard to the RO and the request on it. Can you include a restriction from the street on the block they live?
So with this, you can ask that the restraining order include a stay away order. Often it's 100 yards, which is 300 feet. So that can include an order that can mean that the abuser can be ordered to stay 100 yards from the senior's home. So that may well encompass the block that the senior lives on. You can also ask for a further distance, and maybe the judge will agree the abuser should stay further away. If the abuser lives on the block, however, say if the abuser is your neighbor, you are not going to be able to get an order that the your neighbors stay, away from their own home. You're not going to get an order that the abuser stay off that block because the abuser lives in their own home on that block, and a judge just isn't going to order someone to move out of their home like that. So I'm going to say it depends on whether you can get whether you can get an order that an abuser stay away from your block is going to depend on the facts of the case. But yeah, if the abuser, you may well be able to get an order that the abuser stay away from the block that you live on.
Okay, that looks like it's all of the questions. I'm gonna stop record. Oh wait, we have one. Financial abuse. Client was financially abused by a homeless man who took $100,000 and made credit card charges. Family petitioned for conservatorship. Can they reverse the credit card charges made by the abuser?
I'm gonna say they absolutely should try to reverse the charges. They should report this to the credit card company, the bank, and let them know that it was fraudulent, and maybe put a fraud alert on their credit report. And I'm going to say I hope that they can reverse it, though sometimes banks can be a little intransigent when it comes to this kind of thing.
They're also adding on to that they were diagnosed with dementia.
So I'm going to say I hope that they can reverse it. They absolutely should try. And I would hope that the bank would help them out, or the credit card company would help them out.